Good morning, Senators. My name is Maya Ragsdale, and I'm the co-executive director of Beyond the Bars and a licensed attorney in the state of Florida. I want to spend a little bit of time today clarifying what the Labor Pool Act does and address some common misconceptions about what would happen if it were repealed. This legislature has clearly stated that we need a consistent state standard rather than a patchwork of local rules across 67 counties and many, many more cities. That's exactly what the Labor Pool Act provides. If repealed, most protections in the Labor Pool Act would be lost entirely. For example, labor pools must provide itemized pay stubs, ensuring seating for workers waiting hours for assignments, and cannot block permanent job offers from third-party employers. These protections do not exist anywhere else in federal or state law. Other protections in the Labor Pool Act would be weakened significantly. For example, labor pools cannot deduct so much from a paycheck that it falls below minimum wage. Without this law, federal and state law would allow deductions specifically for meals and transportation, even if they reduce pay below the minimum wage. Labor pools also cannot charge workers for required uniforms or safety gear under the Labor Pool Act unless the worker fails to return them. Federal law only prevents employers from charging for PPE, and there's no state equivalent. Despite these clear limitations in state and federal law, which were the reasons for the creation of the Labor Pool Act in the first place, some proponents have simply claimed that Florida's state OSHA will fill in the gaps. That is false. In 2021, this legislature acknowledged the lack of a state OSHA and directed the governor to explore creating one, which she estimated could take up to 9 years. The only related state entity is the Occupational Health and Safety Program, OHSP, under the Department of Health, which focuses on employer education, not enforcement. And anyway, that office is funded by federal NIOSH, which laid off 90% of its staff last week. The critical and unique protections in the Labor Pool Act are currently enforced through a private cause of action, as outlined in Section 448.25 of the Florida statutes. The absence of a dedicated enforcement agency does not make the law unenforceable, despite claims to the contrary. This bill is advancing based on incomplete and inaccurate information. We urge you to pause, to reconsider, and account for the nuances of the Labor Pool Act. Please vote no on SB 1672.
Mr. Chair.
Thank you.